the ruling that could redefine everything. Every 10 years or so, the Supreme Court picks up a case that reshapes how Americans live out a constitutional right. Heller secured individual gun ownership. McDonald applied that right to the states. Bruen reset the rules for carrying firearms in public. Now, the court has taken up Wolford v. Lopez, a dispute that might decide whether Americans still need state approval to carry a weapon at all. It began in Hawaii, but the fallout could unravel permit systems across New York, Maryland, California, and every state that treats self-defense as a conditional benefit. For the first time, the justices skipped years of lower court battles and seized the case early, a sign of both urgency and frustration with how judges have applied Bruen. A wide ruling could erase today's permit model. A narrow one might still close loopholes. Either way, this isn't just about Hawaii, it's about who chooses how Americans protect themselves, the state or the citizen. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearms statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Section 1. The Supreme Court jumps in early. Normally, the court waits for a case to wind through trial, appeals, and a final judgment. That slow track isn't optional. It shields the justices from premature decisions. Yet in Wolford v. Lopez, they brushed aside most of that process, granting review at the preliminary injunction stage, a step reserved for urgent constitutional questions. Why the hurry? After Bruen dropped in 2022, several states stacked new limits that probed the edges of the ruling. New York, New Jersey, Maryland, and Hawaii led the pack. Rather than outright bans, they layered sensitive place expansions, default property rules, and permit hurdles so steep the right vanished on paper. Lower courts split. Some followed Bruen and struck the new schemes. Others, especially the Ninth Circuit, left them intact. The Supreme Court had already issued multiple summary orders telling judges to rethink cases under Bruen, including Antoniuk out of New York and Coons from New Jersey. Those instructions were mostly shrugged off. By stepping in now, the justices signal they will not wait for the system to fix itself. Case background. Bruen demands text, history, tradition. Young v. Hawaii showed Hawaii's pre-Bruen defiance. Antoniuk and Coons revealed post-Bruen resistance. Bottom line, when the court grabs a case this soon, it already knows the error needs correcting. Section 2. Hawaii flips the script. After Bruen, most states trimmed may issue regimes into shall issue compliance. Hawaii went the opposite direction. It inverted the legal presumption for private property. Rather than lawful carry unless forbidden, the default became unlawful carry unless the owner explicitly allows it. The fallout was huge. Grocery stores, gas stations, malls, parking lots, any privately owned spot open to the public became no-carry zones unless a shopper somehow secured prior consent. A license no longer opened the door. Individual permission did. Why that matters. Constitutionally, the burden shifted 180 degrees. The state no longer had to justify a ban. The citizen had to justify exercising a right. Courts have rejected that flip before. Heller said keeping a firearm does not hinge on government approval. McDonald bound the states to that guarantee. Bruen confirmed public carry as a core part of the right, not a bonus privilege. A federal district judge applied Bruen and tossed Hawaii's law for lacking historical twins. The Ninth Circuit reversed, reinstating the regime and clashing head-on with Third Circuit decisions in New York and New Jersey cases. Takeaway: Hawaii never banned carry outright. It simply made ordinary life incompatible with exercising the right. That contradiction catapulted the dispute upward. Section 3. DOJ refuses to defend the law. The biggest surprise arrived not from Honolulu or San Francisco, but from Washington. The Department of Justice filed a brief siding with the challengers, agreeing that Hawaii's scheme overshot constitutional boundaries. Federal refusal to back a gun regulation is almost unheard of. Even under administrations friendly to gun control, the DOJ usually argues for broad enforcement power. Here, it walked away. Legal fallout. Stripped Hawaii of heavyweight support. Signaled the law fails even under a deferential lens. Boosted plaintiffs' claim that carry cannot be treated as presumptively criminal. The move also tracks Bruen's history test. The government must locate 1791-1868 analogs for any modern limitation. None exist for a blanket private property presumption. In past cases, Heller, McDonald, even parts of Bruin, the United States defended certain rules, yet it declined to defend Hawaii's across-the-board default ban. Key point: when the feds bow out, the runway clears for a decisive court ruling. Section 4. Circuit split leaves no middle ground. The justices are obliged to resolve clashes among the circuits. After Bruin, the Third Circuit voided multiple sensitive place and property default regimes in New York and New Jersey, and Tanyuk, Ihai, Coons. The Ninth Circuit upheld Hawaii's mirror image, letting it snap back into force. The result: two conflicting constitutional visions. East Coast view: carry is the baseline. Restrictions need justification. West Coast view: restriction is the baseline. Permission needs justification. Rights cannot mean one thing in Philadelphia and the opposite in Phoenix. The court has stepped into similar splits before. McDonald on incorporation, Carpenter on cell site data, Dobbs on abortion, when geography decides freedom. Bottom line: the split made Woolford a national, not local, fight. Section 5. Hawaii's argument unravels. Once review was granted, Hawaii pivoted again. It suddenly claimed the case needed more evidence, discovery, and time. Arguments it never pressed below. In fact, it previously told the Ninth Circuit the suit raised pure constitutional questions with no factual disputes. That flip hurt. Appellate courts prize consistency. Shifting theories midstream smells of delay, not defense. Constitutional litigation sometimes banks on running out the clock, but the Supreme Court refused the stall. The state's contradiction revealed it had exhausted its reasoning. A similar collapse happened when New York, post-Bruin, tried to pepper maps with fresh sensitive places. Judges reminded officials that inventive restrictions are still restrictions. Bruin did not craft loopholes, it closed them. Lesson: by contradicting itself, Hawaii surrendered narrative control. Section 6. Weaponizing private property law. Hawaii's statute uses property rights to accomplish what explicit bans cannot. By presuming carry forbidden everywhere unless an owner opts in, the state forces licensees to seek affirmative consent before exercising a right that should be presumed. That collides with Bruin's historical analog requirement. No founding-era tradition allowed government to preemptively bar carry on all private land. Early America relied on posted signs, oral warnings, or trespass law if an owner objected. Real-world result: gas stations, supermarkets, restaurants deemed off-limits by default. Parking lots become gun-free zones without a single sign. A state-issued permit morphs into a hollow sheet of paper. If the court tolerates the tactic, copycat bills will bloom nationwide. Banning locations achieves the same result as banning carry itself. Section 7. Bruin returns to center stage. Bruin declared that public carry lies at the Second Amendment's core. Woolford tests whether lower courts will honor that holding. What Bruin changed: ended interest-balancing tests, rejected generic public safety pleas, demanded historical twins for every limitation. The Third Circuit followed that formula. The Ninth Circuit ignored it. That divergence is precisely why Woolford reached 1 Street. Short version: this case is not a mere island dispute. It is a referendum on whether creative doctrinal dodges can dilute Bruin without openly defying it. Section 8. The Lower Court Rebellion. Since Bruin, the justices have issued several GVR orders: grant, vacate, remand, telling lower judges to redo cases under the new history-only test. Some complied. Some shrugged. Others recast Bruin into something unrecognizable. Woolford offers the court a chance to reassert hierarchy and remind the judiciary that Supreme Court precedent is binding, not suggestive. Stakes: if misapplication goes uncorrected, the Second Amendment will fracture into regional bundles of rights. A freedom that means one thing in Sacramento and another in Savannah is no constitutional right at all. Short takeaway: zip code justice is illegitimate. Section 9. Permits in the crosshairs. Although Woolford does not attack permits head-on, its logic undercuts them. If carry is presumptively lawful on private property, licensing systems that act as prior restraints grow harder to defend. Bruin let permits stand only as objective gatekeepers, make carry the default, and the permit's purpose withers. In restrictive states, the entire edifice could crumble without a single line about permits in the opinion. Exposure map: New York, New Jersey, Maryland, California. View high risk. Constitutional carry states not reinforced. Middle ground states forced to choose. A wide Woolford opinion could end the permit era without naming it. Section 10. What happens now? Briefing is underway, amicus piles are growing, and oral argument is on the horizon. A decision could land within months. Two paths: narrow, strike Hawaii's inversion, leave permits shaky but standing. Broad, announce carry as presumptive, destabilize licensing coast to coast. Everyone involved, justices, litigants, states, knows the stakes. Short takeaway: Wolford v. Lopez is not about Hawaii. It is about whether Americans must still beg government for the tools of self-defense. The permission question. Whatever the final vote, Wolford forces the country to confront the biggest Second Amendment question of the era. Do Americans need the state's okay to defend themselves? For half a century, the permit machine answered yes. Bruen shifted the burden. Wolford might erase it, not by deleting permits, but by defining self-defense as the normal state of affairs rather than a special exception. That is why this case feels different. It is not about islands, property signs, or fine print rules. It is about who draws the borders of liberty, the citizen or the government. Briefs are flooding in, arguments are coming, and an opinion could arrive faster than most expect. Whatever the holding, it will set the distance the Second Amendment travels after Bruen and decide whether the age of permission-based carry is drawing its last breath. Stay alert, stay informed, and stay engaged. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.